A wife being divorced or left by their husband only to succeed in life, have a huge profitable business and tons of cash. And then one day, the former husband that left you wants a piece, if not half of what you have. This is the case of Dorn, a Filipina who was divorced in the USA by his husband, only to be sued as the latter's wife in the Philippines. Disclaimer: our vision laws are based on actual cases. The facts stated have been made public via publications and the internet. If any details, especially of the petitioner, dependent, and or of the dependent accused, offensive in any way, kindly leave a comment or message us in Facebook, and we will be more happy to change any details accordingly. There is no divorce in the Philippines, but it's a different case when you're married to a foreign spouse. Alice, a Filipino citizen while private respondent is a citizen of the United States. That they were married in Hong Kong in 1972. After the marriage, they established their residence in the Philippines. They had 2 children. Unfortunately, parties were divorced in Nevada, United States in 1982. The petitioner has remarried also in Nevada, this time to Theodore Van Dorn. On June 8, 1983, private respondent Richard Upton, former husband, filed a suit against his former wife, Alice, in a civil case, Regional Court, in Pasay City, stating that her business in Ermita, Manila, the Galleon Shop, is a conjugal property of the parties, and asking that Richard Upton, former husband, an accounting of the business, and he be declared with the right to manage the conjugal property and business. Alice moved to dismiss, arguing that they already divorced before the Nevada court, wherein both acknowledged that there is no community property as of June 11, 1982. The court below denied the motion to dismiss in the mentioned case of the ground that the property involved is located in the Philippines, so that the divorce decree has no bearing in the case. The denial is now subject to this certiorari or review proceeding. The issue now is whether or not the foreign divorce of the parties and their alleged conjugal property in the Philippines are binding. The Supreme Court said yes. The Nevada District Court, which decreed the divorce, have obtained jurisdiction over the petitioner who appeared in person before the court during the trial of the case. It has also obtained jurisdiction over private respondent who, giving his address as of number 381 Bush Street, San Francisco, California, authorized his attorneys in the divorce case, Carft and Graft Limited, to agree to the divorce on the ground of incompatibility in the understanding that they were neither community property nor community obligations. It is true that owing to the nationality principle embodied in the Article 15 of the Civil Code, only Philippine nationals are covered by the policy against absolute divorce, that the same being considered contrary to our concept of public policy and morality. However, aliens may obtain divorce abroad, which may be recognized in the Philippines, provided that they are valid according to their national law. In this case, the divorce in Nevada released private respondent from the marriage from the standards of American law, under which divorce dissolves the marriage, as stated by the Federal Supreme Court of the United States in Arterton v. Arterton. The purpose and effect of a decree of divorce from the ban of matrimony by a court of competent jurisdiction are to change the existing status or domestic relations of a husband and wife and to free them both from the bond. The marriage tie, with thus then severed as to one party, ceased to bind either. A husband without a wife or a wife without a husband is unknown to the law. And the law provides, in the nature of a penalty, that the guilty spouse shall not marry again, that the party as well as the other is still absolutely freed from the bond of former marriage. Thus, pursuant to his national law, private respondent is no longer the husband of the petitioner. He would have no standing to sue in the case below as a petitioner husband, entitled to exercise control over conjugal assets, as he is bound by the decision of his own country's court, which validly exercised jurisdiction over him, and the whole decision he does not repudiate. He is stopped by his own representation before his court from asserting his right over the alleged conjugal property. To maintain, as a private respondent does not, under our laws, petitioner has to be considered still married to private respondent and still subject to wife's obligations under Article 109 of the Civil Code cannot be just. Petitioner should not be obliged to live together with observe respect and fidelity and render support to private respondents. The latter should not continue to be one of the heirs with the possible rights to conjugal property. She should not be discriminated against in her own country. If not, the ends of justice are to be served.